Hello students, the topic is law on sedition. So first let's know about the sedition. So if anybody spread hatred against the government which can destabilize public order, then that act is called sedition. Another important concept is the law commission. The law commission is the executive body established under the government of India to do research and suggest changes in the law reforms. Recently, 22nd Law Commission gave many reports, and in its 279th report on usage of law of sedition, it has recommended to continue the sedition law. Now here, let's look into both positive and negative aspects of the sedition law. So it was when we come at the origin of the sedition law in India, it was introduced in India during the British rule to arrest our freedom fighters who questioned the unlawful activities of the British government. Balagangadhar Tilak, Aurobindo Ghosh, Mahatma Gandhi, all these great leaders were arrested under the sedition law. So many of us question to remove the sedition law as it violates the freedom of speech and expression. But the real problem is there are many unseen anti national programs that are going on in India. Some are encouraged by the enemy countries, some provide funds to some unethical organizations, that is NGOs in India, to raise anti national programs that might tear apart the unity and integrity of India. So, for all these activities to counter, the sedition law is very important for our country. Even though we have Unlawful Activities Prevention Act and National Security Act in order to counter the terrorist activities, to remove the foundations of terrorist organizations, sedition law is very important and it is needed for our present situation. It is okay for saving the unity and integrity of India, but at present scenario, many journalists, many leaders and other innocent people are not able to question the government full-fledgedly, because whoever questions the government or criticizes the party in power for its activities, all those people who are questioning against them are thrown into the jail without any notice and are kept for a very long time in jail. So filing a case under the sedition law itself becomes a punishment, and misuse of this law is leading to harassment of innocent people under the sedition law. So, Law Commission has suggested that sedition law should be present, and equally proper procedures also should be laid down to prevent its misuse. So there are some cases in which the Supreme Court has given its judgment on section 124A of the sedition law. Look at this box over here. The first case is Romesh Thapar versus State of Madras. So, in this Romesh Thapar versus State of Madras case of 1950, Supreme Court stated that expression of dissatisfaction and criticism of the government will not come under the sedition law. In the second case, that is in Kedarnath Singh versus State of Bihar case 1962, the Supreme Court has stated that sedition law is needed to protect the state from the forces that may pose risk on the safety and stability of the state. In the third case, that is Vinod Dua versus Union of India case of 2021, Supreme Court has stated that every citizen has the right to criticize and comment on the government functionaries as long as they do not promote violence. And in the fourth case, that is in SG Wombadkar versus Union of India case of 2023, the Supreme Court has stated that the Supreme Court stated to suspend all the cases under the Sedition Act of 124A of IPC to all the state governments and the central governments because of its overusage. So this is about the complete idea of the sedition law and its cases.